The signature reform in the Defamation Act of 2013 is to be found in Section 1, which imposes a threshold of seriousness on defamation actions. It provides that defamation actions will no longer be permitted to proceed unless the claimant has suffered or is likely to suffer serious reputational harm, or in the case of a body that trades for profit, serious financial loss. It's a reform about trivial defamation actions. It may ultimately be of more symbolic than practical import. Courts had already in recent years developed principles and procedures for weeding out relatively trivial defamation claims. Nonetheless, the provision will serve to deter and fortify courts in bringing to an end defamation claims of marginal merit. In my view, the most important reform in the new law is likely to prove to be the new defence of honest opinion, which replaces the ancient common law of fair comment, which is abolished by the Defamation Act of 2013. The new defence is much more liberal than the defence it replaces. It's capable of protecting honestly expressed opinions, as opposed to assertions of fact, on any subject matter. The defence appears to be capable, in some circumstances, of protecting the expression of opinions that could have been held by an honest person, even on the basis of an incomplete or distorted view of the underlying facts, or on the basis of facts that were not known to the publisher at the time of publication and upon which the opinion was not based. In each of those respects, the new defence of honest opinion is quite a radical liberalisation of the law. The Defamation Act of 2013 also abolishes various other defences, including the common law defence of justification, or truth, and the so-called Reynolds defence, the defence developed by the House of Lords for responsible journalism on matters of public concern. The new Act replaces those abolished defences with statutory codifications, which are likely to give rise to a number of ambiguities and uncertainties. As well as those reforms, there are a number of internet-friendly features about the Defamation Act of 2013. Courts, for example, will no longer have jurisdiction to hear and determine most defamation actions brought against secondary publishers of defamatory statements, including internet content hosts and service providers, as well as other kinds of secondary publishers. Examples include news agents, libraries and bookstores. Also of note is a new defence in the Defamation Act of 2013 for operators of websites in cases involving allegedly defamatory statements that have been posted by others online, something that the internet industry had been calling for a number of years. Operators in such cases, and examples will include the operators of news websites, for example, or other online forums, those operators will generally now have an immunity from suit where they comply with tightly prescribed regulations and act as a point of liaison between complainants, people aggrieved about matter which has been posted via their websites, and the posters, the anonymous posters of allegedly defamatory statements. A single publication rule has also been introduced, another matter which the online industry had been calling for many years. Aggrieved persons from the 1st of January 2014 will generally have only 1 year from the time when an offending statement first became available before bringing a claim. So in most cases that means complainants will not be able to sue in respect of statements that were first published a long time ago but which remain accessible online, for example from online archives and the like. And that immunity will continue to apply even where new facts have emerged since the material was first became available, which has the effect of changing the complexion of the statement. So it's quite a radical reform. There are other notable reforms in the Act as well, inspired in part by the controversy that erupted when the British Chiropractic Association sued Simon Singh over an article in The Guardian. There's a new defence in the Act which is designed to protect defamatory statements that appear in scientific and academic journals that are peer-reviewed and in assessments of the merit of peer-reviewed articles. Paradoxically, the new defence wouldn't have assisted Simon Singh because The Guardian is not a scientific or academic journal and nor are the articles in the newspaper typically peer-reviewed. Nonetheless, the legislature has seen fit to extend greater protection to publishers of material in peer-reviewed journals. There are some other liberalisations which are of note. Some are quite significant. For example, the traditional categories of absolute and qualified privilege have been expanded by statutory reforms in some respects.